Welcome to #Lawyered, and today is Guardianship 101, because you know what? If the Queen of Pop is in a guardianship situation, clearly we need to know all about it. Hey y'all, welcome back to #Lawyered. You of course have Austin and myself.
Talking about Britney Spears again today.
Britney Spears.
This is our first repeat, this is our first repeat story that we've had.
Yeah, but it's not really a repeat story because I think last time we talked more about like the history of why Britney was under a management conservatorship and like the psychiatric hold, and kind of we glossed over what conservatorship in California, which is similar to guardianship in Texas, like what that is.
Yeah.
Today is much more of a, yes, well, we're inspired by Britney claiming she wants another baby, but she's being forced to keep an IUD that she didn't want to keep in, so she can't reproduce, which I have opinions on that. But
I guess it's just our first follow-up story that we've had.
Yeah, it's a
with the story that
story.
we laid the groundwork when it was a long time ago.
It was back in like, I want to say February?
Yeah, I think so.
March?
Yeah.
It's a while
of
ago.
last year.
Of last year, yeah. It was a while ago.
Yeah, so it's been interesting to see here in the last couple of days the outrage of a lot of people on social media.
Outrage is one word for it. Okay, so you know what's interesting? True life story. I was at an inspection in the middle of like nowhere, small town Texas, a couple weeks ago. And my expert's assistant shows up, right? So they're taking measurements. The opposing counsel's like, oh, watch out for snakes. And I was like, what the F? There are snakes here? So I'm like freaking out. And of course, the expert's assistant is diving under like the first floor of the house to take pictures of the support beams. And then he comes out and we're all at lunch, the three of us, he's like covered in dirt. And he's telling me, you know who my idol is Britney Spears. And I can't stand, and this is a man, by the way. He's like, I can't stand how she's being treated. It's against her human rights. And I'm sitting here and I was like, oh.
Was his voice really like that, or is that just your...
This is my paraphrase. He actually, he had a very normal voice.
Yeah, I'm kidding.
Yeah.
And that's a microcosm of a lot of people's reaction to this situation because they don't fully understand what's going on.
Yeah.
I think one of the biggest things, one of the things that you and I spoke about yesterday is, and I learned this from the Prosecco Princess.
Prosecco Princess. Do you and Prosecco Princess go way back?
We don't, but I had a friend share a tweet that she put out, I guess. So that's how I learned about this. That there's an outrage about the fact that Britney is having to pay for all the lawyers that are involved with the case. On the surface, okay, yes, I get that sounds a little bit...
For background context, Britney Spears was like this past week, I think, and this is, what day is today? It is June 25th. Okay, good with numbers. Anyway, so I think it was earlier this week that Britney Spears showed up in court and had the opportunity to speak to the judge about her managing conservatorship, right? So basically guardianship in Texas is what we would call that. And all the attorneys were there, her attorneys, the attorneys for her guardians were there, or her conservators. And so it was this hearing, and that's what the tweet is referring to, is all the attorneys in this hearing.
Right.
Yeah, just for background, because I'm sure some people, maybe they live under a rock and don't know what's going on.
Yeah, but the point is that that's a pretty normal thing in these contexts.
Yeah, which is very outrageous to people who are not familiar with not just the legal system, but even guardianship. Because in Texas, we do what's called we follow the American rule, right? So usually everyone pays for their own attorneys. Now we have huge caveats when it comes to written contracts, few other statutory exceptions, and guardianship.
Yeah.
Fun stuff. I've learned all about that because I am now certified to practice guardianship, and I am currently litigating a guardianship case out in Tarrant County.
Yeah, that's what we're talking about.
So fun.
This is perfect timing with all of this.
Yeah, the so fun is sarcastic because, not because no, my client's great. It's just, it's a very sad situation.
Yeah.
It's an
a lot of these
woman.
can be. A lot of these can be. And so given your new recent certification, why don't you kind of explain to us what is guardianship in Texas?
I'm so glad you asked. So yeah, what is guardianship? So basically, in a nutshell, guardianship is the legal vehicle in which the state has created a mechanism to take care of people that society deems need to be taken care of. So usually these are people that are these are always people that are incapacitated. Now that incapacitated could be as a matter of law, right? You're a minor, you're under 18. As a matter of law, you are incapacitated because you are not an adult.
Right.
Nothing you can do about it. No ifs, ands, buts. I mean, maybe if you're an emancipated minor, but even then, I'm not sure.
Yeah, and that goes down a different path
We won't.
too.
That's family law. That's you. And so I don't do family law anymore. And then the second one, and this is what we're seeing a lot, and this is what we're seeing with Britney Spears, right? If she was in Texas, she'd fall under this category, is an adult because of a physical or mental condition is substantially, y'all, I only had 1 cup of coffee, unable to, 1, provide food, clothing, or shelter for himself or herself, 2, care for the person's own physical health, or 3, manage the person's own financial affairs, or in this category you don't really hear much about, a person who must have a guardian appointed for the person to receive funds due to the person from a governmental source, right? And so this lovely language comes from the Texas Estates Code section 1002.017. So thrilling to read statutes in the morning.
Yeah.
Yeah. So basically, incapacitated means you can't take care of yourself.
Yeah. You need somebody to look over your financial affairs, look over your health, and there's something that triggers that, which becomes it deems the person incapacitated, and that's why you end up in this situation.
Sure. And I think it's really important to understand that incapacitated, when you're talking about an adult, whether it's a younger adult, say a handicapped child who's 19, or in my case, elderly individual, they might appear completely fine physically, and in some respects, even some respects mentally, appear totally fine. But then there are certain areas where they are completely lack judgment. Mm-hmm. Like, for example, if you have Susie's a 94-year-old woman, and she is roped into the Big Bubble Bonanza scam, right? Susie gets calls from the Big Bubble Bonanza president saying, Susie, congratulations, you've won a lot of money. And Susie's like, oh, sweet, I won money? They're like, yes, you just need to send us $5,000 to show us that you can take care of the money, and then we will send you your $1 million check. She's like, oh, great. Writes off a check for $5,000 to the Big Bubblegum Bonanza people. And then they say, Susie, 2 days later, you sent the check to the wrong place. Here's the address to send it. And then they keep doing this over and over again until they drain her life savings, because Susie is incapacitated when it comes to making financial or complex business decisions. She doesn't understand she's being scammed. Mm-hmm. And this is a situation that we're seeing more and more frequently, typically with the Publishers Clearinghouse scammers.
Sure.
And it's wild. It's really wild, because you and I are sitting here and we're like, clearly these people are being scammed, but because they don't have capacity when it comes to financial or business decisions, they can't understand it. They literally can't get it.
Typically, whenever someone applies to have a guardianship appointed, I'm presuming that there's an attorney appointed for what I'm going to call the ward, basically the person who you're trying to get a guardianship over.
I'm going to stop you right there. So that person is going to be either called the proposed ward or the alleged incapacitated person.
Okay.
And that language is actually really important, because as we get into it, you can't have guardianship or one of the lesser restrictive measures, right? So like a management trust, unless there's a ruling by the court to find that the person is incapacitated. Mm-hmm. So it's actually really critical to have that distinction of, while the guardianship case is pending, to refer to them as the proposed ward or the alleged incapacitated person. Mm-hmm. And some courts make a really big deal about that.
So does the proposed ward have like an ad litem attorney appointed for him or her?
Yes. Okay. So let's run through the process really fast. So say you have, did I say it was Susie with the Bubblegum Bonanza people? Okay. So say you have Susie, and Susie's, adult daughter, Lauren, is very concerned about her. And so she goes to a lawyer and says, what can we do? My mother is giving away her life savings to these scammers. The attorney is going to say, well, you have an option to do guardianship or a less restrictive measure like a 1301 management trust. And in order to do that, you're going to have to petition the court. So let's say that Lauren wants to put an immediate stop and immediate hold and immediately protect her mother from the Bubblegum Bonanza scammers. So she would hire this attorney. She would draft, and this is critical, this attorney has to literally be certified to practice guardianship law in Texas. So if you are not, you can't practice. You can't go before the court and ask. Like, I can go before the court and ask that a guardianship be created, but Austin, you can't because you're not certified.
Gotcha.
And if you do go before the court, some courts will get very angry and throw you out. Like, I've heard about it happening on CLEs and stuff. It's pretty serious. And so, one, make sure your guardianship attorney is certified. It's huge. And so, but say that Lauren's attorney is certified, they go and they petition the court, they do an application for, let's say, temporary guardianship. And so the court will hear the application, and at that point, typically beforehand, once the application is in, the court will appoint what's called an attorney ad litem. And so that attorney is a court-appointed individual that's supposed to represent the ward, but they're really an employee of the court. And so an attorney ad litem does not have the same obligations to the proposed ward that you and I have to our clients.
Yeah.
Our clients have capacity.
Right. Okay. I mean, their job is to basically, they're supposed to investigate what's going on with this person, why they're incapacitated, and then push back, make a recommendation, do something like that. Because if this person doesn't have a lawyer to look out for their interests, then no one's looking out for them.
Not really.
Okay.
So that's actually what the court visitor does. So in guardianship, you have a large cast of characters. Like, there's a lot of tax dollars that go to this. And so the attorney ad litem is supposed to look out for the ward, and it's this tricky balancing act of doing what the proposed ward wants. Here I am, I'm like not even listening to my own advice. What the proposed ward wants, but also trying to find the best route that will protect the ward, proposed ward, excuse me. But often that's a tricky balancing act, and more often than not, attorney ad litems will fall on the side of doing what the proposed ward wants.
Yep.
And so what you're thinking of, I think one of the characters you're thinking of is what's called a guardian ad litem. And so guardian ad litem is also another court-appointed individual, and that's the person who they may or may not be an attorney, but their sole role is to look out for the best interest of the proposed ward and make recommendations to the court.
Yeah.
And then you also have, at least in Tarrant County, what's called a court-appointed visitor. I think we have them in Dallas County too. And the court-appointed visitor is the one who is more like what you were saying earlier. She or he will investigate. So they'll call the attorneys after a hearing, maybe before a hearing, and try to get all the facts. And they will ask for often credit card statements, bank statements, recordings, writings, things that could show whether or not the proposed ward actually is incapacitated the way that Lauren is claiming. And so at that point, once enough information is gathered, the court-appointed visitor will then make a recommendation to the judge, the probate judge that's hearing the case. And of course, as you know, but most of our listeners probably don't know, guardianship is considered a probate matter. So it is always heard within the probate court. It is never filed in the district court.
Yep. And then I guess within that, you can also have people that would challenge that guardianship. Maybe,
yes.
I mean, I guess I'll just throw out for a hypothetical, Lauren's brother, Joseph. Maybe he thinks that Lauren shouldn't be appointed a guardian, or maybe he thinks that there shouldn't be a guardian in the first place, whatever his opinion. So he can actually try and block, or he can jump into the case and fight that, I assume, right?
Yes, he can. And so usually the person fighting it is the proposed ward, because
makes sense.
If they're not completely incapacitated, like they can show up to court, usually they fight it pretty hard.
Sure.
But say that Susie is fighting it, and then Joseph comes in, and Joseph is like, Mom is fine, but Joseph has lived in Miami and has been running a club for the last 20 years and calls his mother once on Mother's Day, and that's it.
Yeah.
So clearly he has no idea what's going on with Susie. But he comes in and he just doesn't want Lauren to be guardian.
Yeah.
He's like, no, I can be guardian, even though he never talks to his mom. So he can come in, he can challenge it, because at this point, Joseph is an interested person because he is a child of the proposed ward. And so he would have standing to challenge this application for temporary guardianship that Susie has requested.
Yeah.
And so what is temporary guardianship, you might ask?
I would ask, yes.
Yes, you would ask. Okay. So temporary guardianship is basically literally what it sounds like. It's a temporary guardianship. Typically what you do is say that Lauren survives the hearing and the judge is like, all right, I see the bubblegum bonanza people are pretty wild. They are very aggressive, and your mother has already sent them $500,000, including shipping a box of cash to them. So we'll put a temporary guardianship in place, and that'll last for 60 days. And the point of the temporary guardianship, right, is to just basically lock down the person's assets, protect their assets, keep them safe, right? Lower credit card limits, right? So like, for example, one of my credit card limits is like $31,000. Someone who's incapacitated to make financial decisions does not need a credit card with that high a limit.
Right.
You should probably drop that to like 1,000.
Yeah. And then I guess it puts decision-making power in the place of the person who's been appointed as a temporary guardian.
Yes. And the order of executed by the court, creating this temporary guardianship and appointing a temporary guardian is going to list out very specifically what a guardian can and cannot do. So for example, say Lauren is created temporary guardian of the estate of Susie. Okay, well, there's been no evidence that Susie can't take care of herself. So Lauren can't all of a sudden say, I'm going to require you to move to a nursing facility, have an in-home nurse, put you on this exercise regimen, so on and so forth. That's not her responsibility.
So when you're saying there's no evidence of Susie not being able to take care of herself, you're talking about like day-to-day physical, medical, that kind of stuff.
Yes.
So Lauren's not going to be able to go in there and make those type of recommendations.
The only decisions that Lauren can make are the ones that fall into the categories laid out in the court order, which is, let's say the court finds that Susie may be an incapacitated person, and so a guardian of the estate of Susie needs to be created. And then the order will list out what Lauren can and cannot do. And that could be reducing credit card limits, like putting money into a temporary guardianship bank account, creating a debit card, creating a TrueLink card, wherein Susie can go shopping for groceries still, and still buy, say she's really into embroidery supplies. But she can't go and withdraw $10,000, and she can't write a check or a cashier's check for $10,000 and mail it somewhere, because all the financial institutions that she's been a part of are now aware of the fact she's under a temporary guardianship, and that her daughter is temporary guardian, and any such decisions of that nature are now going to have to be run through Lauren. Yeah,
and that's how, and obviously Britney Spears is in California, but they call it something different out there. But just for the sake of illustration here, that's how Britney Spears started, this last year, was with a temporary guardianship put in place.
Well, it wasn't it's been like 13 years.
Okay, well, that's how the whole thing started, though, is that it was with a temporary guardianship.
There was a temporary guardianship, that was put into place. But usually a temporary guardianship will continue, right, in Britney Spears' case. And I'm just going to, for the record, I'm just going to call it guardianship because that's what we call it in Texas.
Yeah, that's what I was saying a second ago. We don't need to, our listeners got it. We've said it enough, I think.
Yeah, California is different.
Yeah.
So, but ultimately, usually temporary guardianship will wind up in a permanent guardianship of the estate and or person, right, like you have with Britney Spears. Or you can do, and we didn't talk about this in our last Britney episode, a less restrictive measure or a less restrictive alternative called a Chapter 1301 management trust.
Okay.
So
what's the difference there?
The difference there is that courts in Texas, and I want everyone to be very, very aware of this, it is a beating to get a temporary, or not even just temporary, a permanent guardianship in place or a management trust in place. It is really hard. You have to go through a lot of hoops in order to prove that a person is incapacitated physically, mentally, partially, fully. You have to prove by clear and convincing evidence that they're incapacitated. And that is the highest, as you know, civil standard, right?
Right.
I mean, it's not beyond a reasonable doubt, but it's way higher than a preponderance of the evidence.
Yeah.
So it's hard.
Right.
And
you said that's for permanent?
Yes.
Okay.
It's for permanent, and it's for the 1301 management trust. And so part of that is you have to get what's called a physician certificate of medical examination.
Okay.
So you have to have a doctor come in and examine the proposed ward and determine if they're capacitated, if they have capacity or not. And if you don't do that, well, you're not getting a permanent guardianship or a 1301 management trust.
Yeah. So is it easier to get a temporary one then? Is what it sounds like to me?
Yes, it's easier to get a temporary
Relatively.
guardianship. Yeah, because you don't have to have a CME, certificate of medical examination, at that point.
Okay.
You should get one because usually with a temporary guardianship, you really should get the CME to determine if this person actually is incapacitated. And if so, you need to hustle because you only have 60 days and you need to put the wheels in place turning to create a permanent protective plan for this person. And that's either through permanent guardianship, Chapter 1301 Management Trust, right? So guardianship is up here, permanent guardianship, 1301 Management Trust is a little bit lower. And then you can try to mess around with trusts and stuff later on, but that can get a little complicated.
Okay.
So, but yeah, you were asking me what a 1301 Management Trust is?
Yeah.
So it's a less restrictive measure, which judges way prefer. You still have to prove that the person is incapacitated by clear and convincing evidence. But what the 1301 Management Trust does is instead of creating a guardian, right, so someone that literally is having to look over the shoulder, makes all the decisions, a management trust is basically a financial institution that becomes the trustee of a Chapter 1301, so Chapter 1301 from the Texas States Code. They create a trust to manage all of the assets and property of the, at that point, incapacitated person. Because once you have a hearing and a 1301 Management Trust is created, the judge has to find by statute that that person is incapacitated.
Okay.
So now they are incapacitated, right? So the incapacitated person, they don't have control over their money anymore. And it's this financial institution. So Wells Fargo, Frost, Chase.
Yeah.
You know.
So are they setting up kind of, I mean, it's different because it's under this statutory code, but the functionality, it sounds like, is similar to some of the trusts like Spencer talked about in here, where someone else is controlling it. And I assume at that point, the trustee is controlling how much money is actually being delved out to the incapacitated person.
Absolutely.
Okay, so I could see why a court, policy-wise, I could see the court would prefer that because you're not having the person look over the shoulder being like, don't spend that, but you're letting them spend freely, but you're limiting the pipeline, so to speak.
Exactly.
Is that, okay.
Yeah, it's very similar. So instead of being able to withdraw $40,000 to send to the bubblegum bonanza scammers, she can withdraw, I don't know, maybe $2,500. And she sends it to them. Okay, well, that sucks, but at least she hasn't drained her life savings or drained her retirement benefits and taken a $200,000 tax hit.
Yeah.
So what the trustee is going to do is, she'll have her monthly or weekly spending, however they want to set that up. Yeah. But then they're also in charge, the trustee, of creating distributions from the trust that will pay for Susie's medical bills. Maybe she's diabetic, so it'll pay for her insulin, to be shipped there. It'll pay for her credit card bill. They'll pay for her home insurance and car insurance and things like that. So they manage the bills, and then they also, often there's an investment vehicle. Okay. So if there's, there'll be like an investment vehicle sometimes that they can do. And then if the person had maybe IRA accounts, right? Texas, trust and federal law are funny creatures. You can't, as a general rule, put retirement benefits into a trust. Okay. So there's kind of a couple ways around that. If you don't want to go a guardianship route, you can do a really long, lengthy trust instrument called a retirement, I think it's called like a retirement benefits trust. Okay. Complicated, long, gets the job done, but it can be expensive to set up because there's so much complication with federal law and trust law.
Complex, more complex, more expensive.
Exactly. Or you could also go the route of, yes, you do the management trust, and then the financial institution can essentially, and this is massively paraphrasing here, definitely not legal advice, none of our podcasts are, but essentially the trustee can take the IRA accounts, create a sub-account wherein the required distributions from the IRA are then, once they're distributed, are then automatically put into the management trust. So that way, the actual IRA assets aren't necessarily in there, but they're being invested in there so that it's protected for the most part.
Sure. So you mentioned that the temporary guardianship, it ends either in a permanent guardianship, a 1301 management trust. What happens if the incapacitated person dies while they're under the temporary guardianship?
Well, let's hope they have a will.
Yeah, I mean, because at that point, that really ends the guardianship proceeding,
That yes,
right? Okay.
so if
Because we have a case right now where we're investigating, trying to get the client to sign up with us, and that's happened, where the incapacitated person passed away while the siblings were fighting in the guardianship proceeding, and so now we've got some bigger issues that we're going to have to deal with.
Yeah, well, I mean, was there a ruling? Was a temporary guardian appointed?
Yes.
Okay.
Yes, and there were some injunctions in place and things that have to do. There's business assets that are owned outside of the guardianship that are controlled by some of the siblings and the now decedent, and so there's a lot of things that are swirling around in this situation.
Yeah, a lot of fancy moving pieces. It sounds
fancy moving pieces and family animosity.
So now it sounds like your typical probate case, frankly.
Right.
So yeah, now, I mean, once the individual dies, you can't have a estate that's incapacitated, right? The estate is just the accumulation of liquid and hard assets that the decedent had and left behind. And so at that point, you're now moving from a guardianship situation to just a contested will situation, assuming they had a will.
Yes.
Good. Get a will.
This case is going to get ugly if we're able to close it and bring it in. It's going to be interesting, but it's going to get ugly for sure.
Let me know if you need help. So anyway, have I explained 13-1 management trust fairly well?
Yeah, it makes sense.
Okay.
You're setting up a trust, still gives the incapacitated person some freedoms, but it limits the amount of damage they can do to themselves. Basically.
Exactly. The financial damage they can do to themselves. In terms of their person, they can still do what they want, you know? If they want to go and dye their hair hot pink, that's you do you, boo-boo, that's fine.
Yeah.
Maybe not great if you're like 90-something, but that's cool. You can do that. It's okay. No one can tell you no.
Sure.
And no one's there to make sure she's brushing her teeth, because hopefully she should still be capacitated enough to brush her teeth.
Yeah.
But this is not the situation we find Britney in.
I was just about to say, where is Britney at in all this?
Britney. So if Britney was in Texas, right, she would be under what we call a permanent guardianship of the estate and the person. So in Texas, we like to break them down into two different things. Again, we've talked a lot about the estate. The financial assets of the incapacitated person are controlled by a permanent guardian for the best interest, right? So that guardian owes a fiduciary duty, super high obligation. You have to put that fiduciary's client's interest above your own. Really big deal. And so they have to look out for, in this case, Britney's best financial interest.
Sure.
Which is complicated because this woman is mega wealthy and she has tons of assets and interests in dynamic LLCs and Lord knows what. There's a lot to go on there. Like, frankly, I would want like a bank or like a host of like wealth management people advising the permanent guardian, if not having like an actual financial person be the permanent guardian of the estate. I think that would make more sense.
I agree.
Yeah, I don't really know why her dad is still the guardian of the estate. I agree with people when they say that her dad should be changed out.
I think so. I mean, mainly because everything you just said. Yeah. It makes a lot more sense. It's for her best interest. They have somebody in there who's savvy in this field. It's not just her relative, which, by the way, takes a lot of the objectivity out of that role if you got your dad managing your estate.
Like, it's one thing, for example, if you're Susie and Lauren, and Susie's financial assets constitute an IRA, a bank account with $30,000 in it, and
a house.
Yeah. Okay, that's not really complicated. Right. Even I could manage that. And I am not a numbers girl.
Yeah.
Right? Yeah. So that's not a problem. But with Britney, like you said, we have all of these massive assets and interests in, maybe she has investments overseas. I don't know, but it's a lot.
Sure.
So someone with financial background really, I think, should be the guardian, not her dad.
I agree. So what's this most recent hearing that's got everybody stirred up? What was going on at that?
So the tweet or not tweet, because I'm not really on Twitter. I mean, I'm on Twitter, but I have like 4 posts.
Yeah.
The thing that I've been seeing all about on Instagram is people are horrified by Britney saying that her conservators forced her to get an IUD implanted, right? So an intrauterine device, which is contraception. Can't have a baby if you're on an IUD. It's like basically impossible. And the only way to get around that is to have the IUD removed by a doctor.
Right.
She wants to get married and have the IUD removed and have a 3rd child. And people are up in arms saying that her conservators won't let her. So Britney, right, conservators, guardian here in Texas, Britney has a guardian of the estate, her dad, and then a guardian of the person, which last I heard was like an actual registered nurse or something.
Okay.
I think. Maybe it's changed. Don't quote me on it. But people are horrified. They're like, oh my gosh, this is violating her human rights that she can't have children and parent. That's like a constitutional right. Well, yes and no.
It is a constitutional right.
It is a
fundamental
constitutional
privilege.
right.
Fundamental privilege.
Yes.
Right. But what's the but on this?
When you don't have capacity and you are under a permanent guardianship of the person, you have been deemed to be incapacitated and you cannot make decisions in your best interest for your body.
Yeah. And that goes into the whole due process of the Constitution, because that fundamental right we're talking about was removed through due process, i.e. conservatorship, guardianship proceeding, evidence was put on, doctrine, all that stuff. And so that's when that was the due process she had. And so it does constitutionally follow what the Constitution says.
And so it does follow the due process considerations, right? So long story short, if you're going to remove any form of a constitutionally protected privilege, right? Like for example, if you are Trisha.
Okay.
And Trisha has a baby, but Trisha all of a sudden gets hooked on meth and coke and other drugs, and the baby is left crying and hasn't eaten in 3 days and is like on the verge of death from malnourishment. Okay, well now that baby can be taken away because she is putting that child's life in danger. Is no longer in the best interest of the child. She can have her parental rights terminated. Okay, parental rights you can't remove those without due process, and due process is the court mechanism to ensure that you are heard, your position is heard when someone else, like the state, is intervening and saying, we're going to take away your right to parent or your other fundamentally constitutionally protected privilege. Yeah,
I mean, the simplest way to put it is in that hypothetical, in Britney Spears' situation, it's the court system. That's where your due process
it's the court
is.
System.
Same idea about you have a fundamental right to vote that can be taken away if you're convicted of a felony. Your due process was...
In most states,
so your due process was your
trial
or whatever proceeding that you went through with the charge that was levied against you. So understandable for people that they don't understand the process, or even if they do understand the process, it's understandable to be emotionally upset about this.
Like, look, it hurts like at a gut check level, right? As a woman, I don't want someone to tell me if I can and can't have children.
Right.
I mean, that's terrible. But then you also have to sit here and think about, if the court found her to be so incapacitated, and there's so much evidence that has to be put into place for this guardianship to even be approved in the first place. Like, speaking from experience, you have to have a very strong case. And courts, at least in Texas, do not grant them lightly. Courts really actually don't like appointing guardianships. They barely tolerate granting 1301 management trusts.
Yeah.
And so there has to be so much evidence. And based on my experience, if the court is saying that, no, a guardianship needs to stay in place and they're not going to alter the terms, clearly there's been enough evidence introduced to show the court that, she really lacks capacity to take care of her own body and her own financial affairs. Now, I will say there's a caveat here.
Okay.
Just because you have a guardian of the person appointed does not mean that they automatically have the right to say, you can or can't have children.
Right. Well, because that goes back to the court can dictate what rights you do have or what decisions you can make.
The court not just can, but they must
dictate what you can and can't say. Or not say, but what you can and can't make decisions about.
Exactly.
For the incapacitated person.
So, so for example, if you have, we'll just stick with Britney. So she's saying that she wants to have her IUD removed and have a baby. Okay, well, whether she can or can't depends on the actual language of the order appointing permanent guardian of the person, right? And if this was in Texas.
Sure.
And so you would need to look at that order. And if that order does list out or have a category that's broad enough to encompass managing the ward's reproductive rights, then yes.
Yeah.
The permanent guardian can say, nope, the ward does not have capacity to make decisions about whether or not she should have children.
Yeah.
And the guardian has the say-so, and that's that is the law. You know, whether you think it's fair or unfair, that is the law. And unless there's a showing that somehow the ward has regained enough capacity, that guardianship is going to stay in place.
Yeah, and I think, it raises a moral question of, is it right for courts to actually give people the power to make that decision over the incapacitated person? You know,
but see, there's a moral position, and then there's a legal position, and then there's a societal benefit position.
Yeah.
Right? Because think about it, you know, I'm going to just come out and say it. Like, if the court thinks that Britney should not be having children, she lacks capacity to do so. And I would be concerned for that child. Like, what is going to happen to that third baby? Like, where are her first two children?
Yeah.
You know, I guess she doesn't really get to see them all that much, and people are horrified by that. But at the end of the day, is it because she's a danger to them? I don't know. Because she doesn't have capacity? Because someone who's not, frankly, in their right mind, that could be upsetting at the very least, or at worst, dangerous to children.
Yeah.
And you have to look out for the best interest of the children.
So I'll just devil's advocate, just to kind of get the discussion going. You know, the other part is we've got a lot of people that aren't in guardianship proceedings that probably should not be having children because they're in the same situation, same concern. You're putting kids in danger because you got a bad home life situation, whatever you want to talk about, you know, living in drug houses or whatever it is. Yet they're still able to have kids, and there's no restriction on that. There's no court looking over their shoulder. And so it's interesting to think about, okay, do we as a society, because our laws are driven by what our society wants, right?
What our society wants and needs.
Right. So, you know, is our society, would it be a fan of it? Are we in support of the idea that a court can say, well, because you're in this situation, we're actually going to make a decision whether or not you can make reproductive decisions on your own?
I mean, I think overall, no, but you need to, that goes back to due process, right? Because what human is going to sit here and say, you know, oh, mom, you're leaving this baby alone for 3 days at a time with nothing but a dirty diaper on while you're taking shots of, I don't know if that's what it's called, but heroin up the arm.
Injecting.
That thing. And snorting Lord knows what, and the baby's on the brink of death. Okay, well, I think in that situation, people are going to say, let's take the mom to court, like, get this baby taken care of, let's get this baby safe, but you're going to introduce the due process, right? And so her parental rights at that point could be terminated, but there's going to be a process for it.
And this is after the baby's already been born.
This is after the baby's been born, yes. So I do think that there is, look, I'm not a fan of big government. I'm not a fan of overregulation. Personally, I'm not sorry if that's offensive. I do think, for the most part, individuals can make their own decisions. However, I think when it comes to people or animals, right, babies, animals, they can't speak for themselves. They need someone to speak up for them and to look out for their best interests. And if they're in a position where no one in their family is going to step up to the plate and look out for them, okay, then I think it falls on the state, once they've become aware of the situation, to say, there's something going on here, we need to investigate, and we need to protect our most vulnerable. And I think that's when you need to initiate your due process and look out for the best interests of the baby or for the animal.
Yeah. It'll be interesting to see how this Britney Spears, I don't think this is going away for a while.
No, it's not going away. I frankly think she will be under a permanent guardianship until she dies.
Yeah.
Because, and I know that's an unpopular opinion and people don't like it, but again, just from my experience, the sheer overwhelming amount of evidence you have to even get a guardianship in place. I mean, the amount of evidence you have to even get a temporary guardianship here in Texas, it's a lot. So unless the courts in California are really different than Texas, which I doubt they are, there's very good reasons why there's a guardianship in place.
I mean, you're saying that because one was appointed, there had to have been a lot of evidence, therefore there's a lot of stuff people aren't seeing.
Exactly.
When they're making these
They're not
conclusions.
seeing, here's the thing, is that they're probably not seeing all of the medical evidence and medical records that have been given to the court. Because a lot of this will be, filed what's called under seal, so that they're not available to the public. And so the CME can be public record because that's a court document, certificate of medical examination. But interviews with the doctors reports, experts' reports on her mental health, they're probably not available to the public. And you can't make a decision based on, oh, I think this is wrong that she can't have a baby. Well, you don't know. You don't know if she literally has like something in her brain that could make her be a danger to the baby. What if she what if she's bipolar and she has a horrible manic episode, and in doing so, the baby is put in danger?
Yeah, I mean, I think flip side of that is there's plenty of people that are diagnosed with those types of issues that are having kids all the time. You know? Sure.
That is the flip side, right? But that's just one thing amongst a host of other things.
For sure. And we haven't seen the evidence.
No, we haven't seen the evidence.
It's under seal.
Yeah. And so, but I mean, at the end of the day, I get where people are like, hey, these are fundamental rights and they shouldn't be taken away, but she's under a guardianship. It's for a good reason.
Yeah. So the Free Britney movement lives on.
Free Britney movement lives on. I am not a fan and I am not supporting it.
It will be fun to watch, though.
It will be fun to watch, and you know what? US on Free Britney.
Bring it on.
Bring it on. We'll talk about it in the Texas setting, though. All right, y'all. I hope you enjoyed our Introduction to Guardianship 101, and we'll see you next time.
Guys, thanks for listening. Closing arguments are coming up, but make sure before you go rate, review, and subscribe to our podcast anywhere that you listen to your podcast. Check us out on YouTube, and you can check us out on Instagram and talk to us. Tell us what you want to hear about. You can search us at #Lawyered, spelled out. You can talk to Andrea at andrea.s.turner, and you can talk to me at The Dallas Lawyer. See y'all again soon.
It's another Kardashian closing argument today, because I love them. Anyway, Kanye, I guess who's not really part of the Kardashians anymore, but whatever, is going after Walmart, your favorite giant big box retailer, because allegedly Walmart is selling knockoffs of the famous Yeezy foam shoe. That's right, the foam shoe. And according to Kanye, it is leaving customers in wild confusion when they go to Walmart if they're buying the real Yeezy foam shoe or just a cheap knockoff imitation. Now, I'm gonna leave it to you to figure out if someone going to Walmart thinks they're actually buying a real Yeezy or not. But are there grounds here for trademark litigation? Yeah, there probably are, actually. So let's wait and see how this one turns out.